Intellectual property rights are the rights given to persons over the creations of their minds. It is a legal concept for a range of intangible property rights including trademarks, patents, copyright and designs, and relate to creations such as innovations, inventions, and literary and artistic works. These rights afford owners the necessary protection for their investments, hence incentivizing the creation of intellectual property. Why are these rights important? Because they encourage and stimulate innovation, inventions, creativity, and new ideas. But the failure to enforce intellectual property rights can have a negative impact on our cultural and creative industries and on our economy. It is an issue which affects the broadcasting industry, which deals with a diverse range of musical and audiovisual works protected by intellectual property rights and, more specifically, copyright. It is within this context that the Telecommunications Authority of Trinidad and Tobago held the ICT Open Forum entitled Intellectual Property Rights and the Broadcaster. This forum brought together key stakeholders and members of the general public to better understand the challenges that broadcasters face in relation to intellectual property rights. Mr. Selby Wilson, Chairman of the Telecommunications Authority of Trinidad and Tobago, shared how the authority's work guided the evolution of the industry into its current liberalized state.
Before the liberalization of the telecommunications and broadcasting sector, which culminated in the implementation of the Telecommunications Act, piracy, in particular for cable television, was a major problem in Trinidad and Tobago. However, the market has come a long way in terms of compliance since that time. Over the course of the last 3 years, the authority has been involved in a number of initiatives to regularize intellectual property rights compliance, particularly in the subscription television market. The authority has been working to sensitize cable and satellite television providers to the need for acquiring legitimate rights for all broadcast content. The authority has also been working with the Caribbean Cable Cooperative, a regional body which assists members in acquiring rights for cable content, to assist operators, especially our small cable providers in Trinidad and Tobago, in acquiring the necessary licensing agreements. Given all the issues in the market, the authority has commenced work on a coherent strategy to guide the administration of intellectual property rights in the broadcasting sector. A draft policy for the consideration of government is currently being developed. Once completed, it will be made available for consultation. Notwithstanding current issues in the market, it is important to note that the use of content by broadcasters is not the only intellectual property issue relevant to the sector. In fact, broadcasters themselves are entitled to some type of intellectual property protection in the form of related rights which cover their signals. Furthermore, many broadcasters themselves are producers of content and hence copyright owners. As such, broadcasters are both users and owners of intellectual property rights.
In recent years, rapid technology development has changed the ways in which consumers access music and audiovisual entertainment. This, of course, means that the environment in which broadcasters operate is evolving significantly. President of Trinidad and Tobago Publishers and Broadcasters Association, Ms. Kiran Maharaj, brings to light the current situation facing local broadcasters.
Online. Broadcasters face piracy too online, believe it or not. We have a lot of radio hubs, so you will go to our website and you'll see many Trinidad and Tobago radio stations listed. We did not even know that we were listed, and they are playing the music. Apart from all of that, they are getting revenue because they may have Google AdWords. And to quickly explain what that is, you have your website. There is a space for something called Google AdWords, and an advertiser places ads with Google and says, anybody who listens to anything from Trinidad, that's where I want my ad to pop up. And in their ad server, it pops up. So they, in addition, get revenue for something we are doing. And it doesn't happen with radio only, it happens as well with television. Then we come to a really nice one, public cultural events, Carnival. It has often been argued by some broadcasters, listen, we know it's cultural, we know we have to cover it, but wouldn't it just be less costly for us if we ran, and I'm using, an analogy by a peer of mine who said we should run westerns, because do we cover our costs at all? So what are the real or true copyright issues? If I buy a costume from you and I want the world to photograph me, who retains the rights there? Is it the mask maker? Is it me as the person, the consumer who bought the costume? Is that okay for me to do? If I have a section in the band, can I assign the copyright for images of my section to a media entity? So these are still questions that we need to look at and we need answers for. I talked a little bit about this film. My company was involved as an executive producer, and let me tell you what happened. Chaguanas Market on a Saturday morning, you walk out and you see the DVD. And you say, but hold on, this didn't release in Trinidad yet. Releasing this in a week. But the DVD is there. So I go up to the gentleman and I say, you have to remove these DVDs. You don't have permission to be selling these DVDs. This is going to take away revenue from the cinemas, from myself, from the local crews, because everybody gets paid to work on this, So you have to remove it. He looks at me and he says, it ain't worth much, it have no subtitle. Doesn't take away from the fact. Needless to say, we could do nothing about it. There were numerous attempts to my colleagues at TATT. I even said I would go myself with the police and army or whoever, just allow me to, and get it off the streets. It got nowhere. But it did a lot of damage. I think it was one, because there was a lack of infrastructure to properly regulate it. And I think that there was no clamping down on the DVD clubs and those guys with the carts.
Chief Executive Officer of the Copyright Music Organization of Trinidad and Tobago, Mr. Josh Rudder, emphasized the role and responsibility of his organization for local artists.
As a lot of times persons would see COT as this we just going out after money, but the reality is there's two sides of it. COT is a membership, and a wide membership of creators of music. They've entrusted their rights to us to ensure that we represent their rights and we monitor their rights and monetize especially their rights. And of course we have to determine the value. Of course, and I mentioned it, and Kieran mentioned it as well, the Broadcasting Association, through TATT and the MOU, the existing tariff is 2.5% of the annual advertising revenue, and that's what it currently is. The challenge does exist in terms of, from a broadcast end, the earnings from broadcasts are not the highest in terms of for local membership. It's not. It's a reality. It's not. And of course, the other determining the item to determine value is really improving the dialogue amongst the broadcasters, COT, and all the other relevant authorities.
Regan Ascarali, Legal Officer 2 at the IPR office, highlighted the major aspects of copyright.
The right to be identified prominently as the author of his work and not to have his name indicated on his work if he so desires, he has that power, or to use a pseudonym and to object to any derogatory treatment of his work. Moving along into our area. What are related neighboring rights? Related rights are proprietary rights that subsist in performances, so the singer, etc., sound recordings, and broadcasts. And that is in Section 20 of our Copyright Act. The rights of performers own their performances. And there was a treaty called the WPPT back in 1996, which dealt with that. WIPO's Performances on Phonograms Treaty, and brought performers into this realm of the economic card rights. All right, so I have, unfortunately, I have the light here, but I have a really nice picture of Shakira performing, if you could see in the background. And Shakira has the exclusive rights to do, authorize, or prohibit the broadcast or other communication to the public of her performance. But you would say, okay, well, she's performing, right, and therefore she has all these rights. But how she's going to make money, well, besides going by court, etc. But let's say somebody wanted to film Shakira. It would be in her interest, therefore, to give consent for the broadcast, probably to put it on a CD, to put it, on a DVD especially. And so therefore, it comes down to contract, to consent. And therefore, the broadcaster shares in this economic pie, which is called IP rights. Shakira shares in it, and everybody's happy. The other aspect of related rights, the rights of the producers of sound recordings. And when the guys sat down at WIPO to try and give protection to this, they were wondering, well, what do they really bring? You know, another Shakira, and everybody thinks of these performers. But you know what they bring? They bring that economic clout to put this enterprise together, to produce this sound recording. So they bring something to the table.
In terms of the use of the software, which, like I say, for productivity and utility, public good, you know, the copyright should not be as stringent as for art, because art you consume in the original all the time.
If somebody writes software, you'll try and, in industry terms, shop it, because you would want to make money from it, and intellectual property is all about making money, and because you have a shelf life for it, your life plus 50 years. So you might very well want to license it to somebody with money for it to be used, and then you get back royalties, etc.
I heard a girl sing karaoke, Machel Montano, in a club, and I'm wondering, what's the implication, the ramifications of karaoke singing?
Treat that same concept even with a karaoke, for example. So it's happened, a venue has karaoke live night, and this venue pays a public performance license to cut. And part of paying the public performance license is the usage of music, including the music that is performed, the karaoke music that is performed. And we will then monetize that in terms of ensuring that the rights holders gain royalties.
I think a lot of the issues concerning intellectual property, have been discussed here today, and it's recognized that it's a very complex area. When TATT came into being, we found a market where there was a lot of pirated content within the broadcast industry. Obviously, if we were to take the draconian action just to simply cut all content, there would be no broadcast industry here today. So as a result, over the years, and more stringently over the last 3 years or so, I think as the chair mentioned, we have taken a process which we call regularization, where we have sought to identify first and foremost all the content that is being broadcast by every broadcaster, but primarily targeted towards the cable broadcasters. And we now have a database with all the content and with some understanding, if you like, of whether such content is properly authorized, where we have evidence, we would have seen the contracts, seen evidence that the contract is authorized and is in fact up to date. And through that process, we have targeted various, if you like, channels, where we have been working with the various broadcasters with a view to getting those channels properly authorized. There have been a lot of issues in relation to the identification of the rights holders in some cases, and we have also sought to play a role in that context.